Welcome to Looking at Legal Stuff. Today we have 6 hearings and a motion for contempt with a woman who hasn't been paying her child support. She gives the court one guilt trip after another and comes up with excuse after excuse, all while claiming she didn't want to insult the court with pocket change, which is why she didn't pay anything at all. Dad's lawyer points out that it seems like she wants to play stay-at-home mom to her new baby, but she expects the wrong father to pay all the bills, and with $5,000 in arrears, it's time to seriously consider jail. Let's see what the judge thinks.
I have a matter that I believe it will ultimately be a set over. This is Gilliam and Gilliam, 23004298. It looks like the responding party, Elena Gilliam, is in the courtroom or in the Zoom, but she did not file a response. And so we're just looking to have her file a response and then set it over.
All right. Is Elena Gilliam present? If so,
Yes, I'm here.
All right. So like, I don't know where the feedback's coming from, but it looks as though there was a motion to serve by mail after several attempts were made. And there was an amended order to show cause. Have you received a copy of that?
I did. I received it late as I have been working, and every time I was tried to be served, I was either at work or at a wedding or had my son at the ER with me. So unfortunately, I haven't been able to file for anything because I've been constantly working.
All right. Do you anticipate filing a response?
Yes, I am currently working on one.
All right. How much time will the parties like for that?
I'm fine to set it to the 27th. That gives her enough time to submit something and for me to get in a reply. I would ask that she submits her response no later than 1 week by the 13th. And then that'll give me a reasonable amount of time to submit a reply.
That sounds great for me.
All right. So 27th, I think we technically closed it, but we closed it with a few spots open to set overs. So we'll set this to the 27th of June, 1:00 p.m. And if you could make sure that that's filed, when you do file that, make sure if you can to give a copy to Ms. Baldwin so she can respond to that as quickly as possible. And then we'll see you both back on the 27th of June at 1 p.m.
Very good. Thank you. That matters, right?
All right. Do we have is Kelsey Demeter still involved, or is she no longer a part of this?
She has withdrawn.
Okay. All right. So we're here on contempt. I have reviewed the contempt. I have also reviewed, believe there was a response.
There was.
And I'm ready for any argument.
Very good. So this is a straightforward contempt regarding child support and non-payment of child support. The order of child support was originally a temporary order that was entered in November of 2022. That was followed up by a subsequent final order of child support, I believe, in January of 23. From that original order in November of 2022 through essentially the current date, there's been no payment, no attempts to pay, no plan to pay, and that continues with the reply. We calculated the arrears just through April, because that's essentially where we were when we filed the motion, at $2,532 plus interest. The complaints really are just not grounded in reality that were filed in the reply. There's this sort of allegation, well, they didn't consider my other children, but if you look at the final order of child support, there is a whole family deviation that's already included. The parties considered transportation. This was an agreed child support order. This was no one was forced to sign this. This was an agreement. It did give consideration to those things that are essentially complained of now. The other excuses, again, fall flat. Well, Jay was in the hospital. Okay, that maybe explains a week of the 8 months. It doesn't explain 8 months. She was only in the hospital for I believe, 2 days. So again, where we are is just a simple, and when you look at, again, her statements, there's no plan to pay. There's no, hey, put me on a payment plan. There's just, here's a bunch of excuses and no plan. So we're asking the court to award the full amount of arrears, the full amount of interest requested. She should be required to pay her child support in full and $150 towards the arrears going forward. That's reasonable. That's still going to take her more than a year to pay off that arrearage. As far as the taxes, again, the petitioner in this matter claimed the children for the 2022 taxes. She should not have. Both in the November 2022 order and the final order, my client was to claim the children in even numbered tax years. 2022 is an even number tax year. She was contacted essentially before she filed, said, hey, my client's saying, hey, this is my year to claim. She then runs out and files first, and then my client can never get relief unless she amends her taxes. So again, my client's the primary parent in this case. He was ordered to receive those, and he should have received them. Even if it was her year to claim the children, she could not have, because she's not current in child support. So even if it was her year, still not appropriate. There's really no circumstance where it's appropriate that she has claimed them. She continues to refuse to amend her tax return. We're now 6 months in. We made substantial efforts to gain compliance. Contempt was not our first step. We made efforts. My client made efforts. She just ignored all of those and said, I'm going to do what I'm going to do. And that's not appropriate. In this regard, we're asking the court to order her to file an amended return, removing the children from her return, that she needs to file that with the IRS, provide proof she's filed that with the IRS, and provide a copy of that return to this court. We'd like to see the court set a review so we can review that she's paid child support, and additionally to make sure that she's paid, or that she's filed her amended tax return. I think that that's appropriate in a case where we really have somebody who's been obstinate for, at this point, we're at 8 months in, where somebody's just saying, I'm not going to comply. So with that, we're asking the court to find the arrearage through April of $2,532 plus the interest on that, $1,000 civil penalty. Essentially, we have two very clear contempts here, and just an unrepentant, obstinate individual on the other side. Fees of $3,500. Again, efforts made to resolve this before, and you also see that I had to go through extra efforts to get her served and file motions to serve her by mail, and $130 of costs. We're asking the court to order all of those as well as set a review.
Okay, just quick question. You, what was the amount that you said was in arrears?
So just through April. So based on when we filed, we just went through April. That's $2,532.
So
and then
the 3981 is current.
Yes.
Okay.
And in addition, my client, because the Division of Child Support, we put in an additional declaration. It takes time from the time that the order is entered until the Division of Child Support actually starts acting on it. So my client was continuing to be garnished, even though he was then had no obligation to pay, and actually with the primary and custodial parent at that point. We're also asking for a judgment of $923.52. That's from the time period of essentially November 7th through December 12th. We provided all of those wage stubs that show the garnishments that were happening even after the court had placed the children with my client.
And it is, so that's that plus the current amount is the 3981 in your contempt order.
Yes.
Okay. Thank you. All right, Ms. Stockwell.
Yes, Your Honor. The reason why I wasn't able to pay prior in November, which was stated in the previous casework and everything, before we came to a settlement, was the visitation schedule mixed with the fact that I live in Everett and was having to drive down to Longview area for visitations. I think it was like 3 times a week, which would leave me with no time for work. My husband was having to call out of work to take care of our other child in that time, which was making us lose money in that instance as well. We have been scraping by because I later found out I was pregnant and was put on bed rest due to extreme nausea and a couple other things that were going on in the pregnancy. For the first trimester, it lasted a little bit further into the second trimester. I had an emergency appendectomy, which did land me in the hospital with emergency surgery. Once I was out of the hospital, my midwife required that I stay resting and recovering with a very minimal weight limit for the next month or so. The entire time I was still applying for jobs. I was still looking for work, whether it be at home work or light duty work. Got very minimal responses back, unfortunately. Had an interview scheduled the day I had to have my surgery. It got pushed out when I contacted them again. That position had been filled. Regarding the regarding all of that child support back then, I have been working since April 14th, I believe, is when I was officially hired, and have been working pretty much every single week since then, minus having to cut back hours due to more pregnancy complications, to where I was passing out at work and such like that. Child support division have tried to get in contact with my employer. I have given them my employer's information. I have been in contact with the Division of Child Support, making sure that it would get taken out of my paychecks. She pays through Gusto, so I don't see pay stubs. I don't get pay stubs. I just see, this is what amount you get. Okay, cool. So in my head, I'd already calculated that it should have been pulled out and didn't even think about it. The times that I was had been tried to be served, I was at a wedding, my sister's wedding out of town. I was at work or driving between work to pick up my child, which is in the next town over, to come back. And the other time that would have been able to catch me, I was in the hospital with my son because he had kidney stones. On top of that, the tax return matter, I was advised with my legal counsel at the time, misdemeanor, to file because I never got served any paperwork or informed of any paperwork or given copies of any of the paperwork from November 22 or whatever it was. And so I didn't know that it was already in place saying that he would claim them for the odd numbers. I was not aware of that until, or the even numbers, my apologies. I was not aware of that until the rebuttal just now or the previous one. I have not seen that paperwork. I still have not seen it. I am under the impression that with my legal counsel at the time that I had every right to file. That is why we filed. I am still very new to all this legal stuff, so I didn't know that I couldn't file if I was not caught up to date on child support. And to my knowledge, I didn't know that I was supposed to be paying from November. I thought it started in December. I didn't even know that I had a missed payment. And I have had to take time off to try to find a lawyer and to, my apologies, and to attend these court hearings and to drive down to Longview to even turn in paperwork, which is costing me more money that I could be giving to the kids, which I'm sorry, I'm very frustrated. That I'm trying to get to the kids because I know that they deserve that, and I'm trying to be able to support them on top of the gas money that I have to pay. If I didn't have to pay the entire amount for driving them back and forth, which I tried to resolve with the first settlement, we went back and forth on that. If I did not have to pay the full amount, I would be able to give more and make sure that the kids had money. Um, it also has put a lot of strain on my vehicle to where I've had to have repairs done. And I honestly don't see why, like, anywhere in the paperwork where that would have been taken into account with the child support.
So I'm going to object. We're really far beyond her declaration. I've let it go for quite some time, but we're far beyond.
All right, I'm just reviewing a couple of the things that I'm reviewing the final parenting plan here. Okay. All right. Here's where we're at. I'm going to use kind of a phrase I hate, but ignorance of the law is not, unfortunately, an excuse. You were represented by an attorney. There was a temporary order of child support that was entered effective November 1st, 2022, indicating an amount of support, $300 a month. That was drastically reduced from what was supposed to be paid because of a whole family deviation. And that was also, you were given the opportunity to pay that in 2 portions a month instead of just once a month. So that was entered in November, looks like November 4th is when I signed it. And notes indicate that it was reviewed on the record. Your counsel was present at the time. Additionally, there was an order in place for the taxes. So here's where we're at. I guess thinking that it's taken out of your paycheck and that it's cool probably isn't sufficient moving forward. I am going to make a finding of contempt. I am going to require that you amend your 2022 income tax returns to not include the children or child, excuse me, is it child or children? Children. So Desmond and Amelia. And you will need to file proof of that amended return with the court and on Ms. Baldwin's office. You were receiving support when you were supposed to be paying support. I don't know if you noticed that, but that was that could have easily been kind of siphoned back the other direction. I'm going to enter the judgment of the past due child support and the overpayments by Mr. Gilliam in the amount of $3,981. I'm not imposing a civil penalty. I will impose the cost of $130. And at this point, even though frankly it's not helping Mr. Gilliam, I'm not going to impose attorney's fees either at this point. So I don't think, I think we'll be back here again. Time frame, I guess, Miss Baldwin, what's a reasonable time frame if you know for to get an amended tax return filed and proof back to us? Is that something that 60 days is sufficient?
Oh, she doesn't have a complicated return. So honestly, I think 2 weeks is sufficient. So I would order her to have it completed in 2 weeks and then review it in a month or so. That also can allow us to review where child support's at the same time.
Okay. So we'll review this case, Ms. Stockwell, July 18th at 1 o'clock. You should have by that point filed your amended returns and been able to provide some type of proof to Ms. Baldwin of that and to the court. So I'm just going to change the order. It suggests within 7 days of entry of this order. I'm just going to say 14 days. Of entry of this order, which I'm signing off on today, the 27th. So that means you have until the 11th to file that amended tax return, and then we will review proof of that and where you're at with getting your garnishment set up on the 18th of July at 1 p.m. Right. Good luck.
Thank you, Your Honor.
Gilliam and Gilliam 20-3-00429008.
That matters. Ready?
And I'm sorry, Stockwell. It's not changed in the system, so I always refer to you as Gilliam until I see you on Zoom, Ms. Stockwell. So I apologize. We are here to review the amended tax return
And payments.
and payments.
So we're really in the same position that we were the last hearing. The court entered the contempt back in late June, ordered Ms. Stockwell to file her amended tax return, to file a copy with the court, provide me a copy. That has not happened. There's no evidence of her attempting to make that happen, of her like making any efforts really whatsoever. I do not see that at least anything that she's filed indicating that she's making payments. So really we have zero progress and zero attempts at progress. And again, in a case, and if the court will recall, my client tried to prevent her from filing this tax return wrongfully back in January. We waited, we made lots of efforts over about 6 months to get her to comply. She just was obstinate and refused despite a very clear order. We're really in the same position. There is no excuse on this one for something that's really straightforward. It is taking time and money out of my clients' hands and out of the hands that are the ones that are responsible for feeding and caring for the children. So kind of similar to the last case that you heard, my thought is to kick it out 2 weeks, but if it's not done at some point, the rubber's got to meet the road and jail time is appropriate. I don't want to do that. I want compliance. But if Ms. Stockwell is just going to ignore the court's order, I don't know what other options we have.
Ms. Stockwell, can you update me on the amended tax return?
Yes, Your Honor. I did get that tax return amended on the 9th. In the wee hours of the morning, I was working on it over the weekend after I had dropped off the kids from my visit. I did get them amended, but after amending them, I was left with no money for gas money to get back down to file in the court system or to present Ms. Baldwin's office with a copy of this. I've also made a $90 payment to child support as soon as possible. I had to wait for my check to hit last week for that to go through because again, we were in the hole and didn't have money to be able to get down and get any of that or to put any money forth for child support. And I think that was the topics. I'm sorry, my pregnancy brain is getting really bad.
All right, and I'm assuming, Ms. Baldwin, you haven't seen any payments come through at this point through, and are these payments going through DCYF?
Yes.
Okay.
And so my concern, very similarly, I'm going to throw out my hands and make excuses. Those excuses just really fall flat. I couldn't get down there for gas. I have email. I have mail. The court has mail. She could, if she says she did it on the 9th, we're 9 days past that. She could have put it in snail mail and we'd all have it by now. I mean, she did, which leads me to suspect that she hasn't done it. So again, the concern there just isn't an excuse to not have, paid 60 cents for a stamp and put it in the mail. And so no excuse there. I don't think she's made a payment. She says she's going to make a payment. ASAP. And a $90 payment is not cutting it. Again, there's not any excuse that she has. The child support order is at least $480. And hey, I'm going to pay what amounts to a 20% of that isn't acceptable. She's not providing you any sort of plan for how she's going to even pay current support. It's just, I'll pay what I want to pay. That's not what the order is. You have to pay the court ordered amount. And so again, we just have somebody says, I'll do what I want. And that is not appropriate. And so same request over 2 weeks, she needs to provide it. And if she doesn't start making real payments, then jail time seems to be the only option to get her attention. Not what I want, but when people just sort of thumb their nose at the court, at some point we have to get their attention.
Unfortunately, the $90 was garnished from my paycheck and was half of my check. Therefore, we do not have the money to put forward yet. My husband does get paid this week and we can put more towards it. But I have paid as much as I possibly can up to this point, as again, with all of the bills and everything coming in. I am more than happy to provide proof of our bank statements or anything needed. And I have contacted Mr. Gilliam to get an email to send those, and he has refused. So I have not been able to email Ms. Baldwin. I can't find it online. I've looked in many places. And I'm not making excuses. I'm genuinely trying to do this. This has been a very big stressor. And I'm doing my absolute best at picking up shifts at work. I'm trying to do odd errands for people to make up money to be able to pay the child support.
I'm assuming Ms. Baldwin would be more than happy to give you her email address right here and right now if you have a pen and paper.
Yes, I do.
If she has it, I can just put it in the chat. That's probably easier.
Or that. Are you able to see the chat if that, Ms. Stockwell?
Yes.
Okay, so Ms. Baldwin's going to send you her email through the chat. I'd ask that the amended return that you said was filed on the 9th of July, please provide that to her via email. And if you can put that, if all you can do is mail it to the clerk's office, mail it to the clerk's office. That address is readily available online. We're in a situation where I mean, I don't know. I know that you're currently pregnant. Is that correct?
Yes, I am due on the 2nd.
And the last thing we want to do is put you in custody, but you have obligations to other children that are still that are here already in the flesh, and we can't. We have to be considerate of those children as well. So we'll set this to the 1st. You need to provide email Ms. Baldwin by Thursday, the 20th, close of business with that amended income tax return, and please mail it to the court, the Superior Court Clerk's office, and then we'll review this on the 1st at 1 o'clock.
Sounds good. And we'll try to file an updated debt calculation for the court as well.
All right, thank you. All right, Gilliam and Gilliam 20-3-0042-908.
That matters, right?
All right, and I did see, let me see, there was an email that your office sent Miss Baldwin with an updated sheet. Let me just.
Yes.
I get so many emails, things get buried so quickly. Let's see here. When did you send that last week or was it earlier this week?
It must have been last week because my filings shows December 1. So it must have been last week. Probably Friday.
It is. Oh, so I should have looked there first. Okay. So the respondent's debt calculation, I see the updated it's dated from the Division of Child Support 11/29/23. Okay.
Correct.
Do we have Mr. Gilliam?
And not Mr. This is Mrs. That is the
Oh, I'm sorry. We have Miss Gilliam, which is, I'm sorry, Stockwell now.
Yes, she was. Oh, and there she is.
She's here, yes.
Yes. So we're on here today for review regarding contempt. And my concern is we really have not changed course. If you look back through the pleadings, we've started the contempt back in April. It took us some time to serve Ms. Stockwell. We were before the court, I believe in June. And then we had a review, and then we set this review out even further. The issue here is that when you look at the debt calculation, we have no child support payments made in January going all the way to June. We have her basically getting served, the court kind of giving her some ultimatums. So we see a small payment in June, a small payment in July, and then once again, nothing in September, nothing in October, nothing in November. Here we are, December. So if you look at this sort of little debt calculation just for 2023, and assuming, here we are December, not seeing any payments made. So essentially over the course of a year, we have 2 months out of 12 where anything has been paid. And I always have a concern when somebody pays nothing, month after month of $0 paid. So it's not, I couldn't scrape together 20 bucks. I couldn't scrape together anything. And so that does get to where we're talking about intransigence, is somebody who just says, not going to do it, and you can't make me. And that's where the teeth of the sanction, unfortunately, need to get sharper for Ms. Stockwell. My client's been very patient. We've kicked this out, for not just like a month or 2 weeks, get a payment, but sort of like months at a time, saying, hey, kind of get it together and start making a plan and start making payments. And Ms. Stockwell just, instead of sort of taking that grace from the court and from my client, has kind of just blown it off. At this point, we've been at this again since April when we filed the contempt. We're kind of done with some of those simpler encouragements. And we're at the point where we need some teeth to get Ms. Stockwell to get real about the fact that she has to make payments. She has to pay child support. So at this point, I think what is most appropriate, we've got a couple weeks. So either I'd like to come back on the 26th, or in my preference is the 26th because Your Honor is here. And I know that the docket changes in January. But essentially, I'd like to see some real payment this month. And if she doesn't, that she shows up on the 26th in person, ready to spend some time in jail until she writes a plan on how she's going to pay. Because so far, none of this has gotten through to her, and it's been an extended period of time where these children who are entitled to support aren't receiving it.
Thank you. I just, for the record, I do see that, so there was an order on contempt that was entered in June for the April contempt. And then there was, it appears, a satisfaction or partial satisfaction, a judgment in July after another, after the amended tax return was ordered. And then in August, there was another $250 in attorney's fees ordered. I'm assuming that, or has that been addressed? No.
She has not paid those. And we've tried to give her credit anywhere where it's appropriate to do so. And you can kind of see from that debt calculation that in August, she paid a little bit over the total arrearage, I think by about almost $300 over the sort of monthly amount towards the arrearage, which was good. But then once again, no payments thereafter.
All right. Ms. Stockwell, any updates for the court here?
Yes. So we have been trying to figure out how to piece together a plan, because the day after I had my baby, we got hit by a drunk driver and my car got totaled. So I haven't been able to return to work for lack of transportation, and lack of childcare for lack of transportation. And we've been scrapping together and trying to piece together money, and neither of us felt like the $20 would make a difference. So we've been trying to make sure we are able to pay a lump sum so it doesn't look like we're just, here's pocket change sort of thing. We've been trying to rework billing We've put off paying multiple things, just trying to come up with the money. Right now we're in this space where if we have to choose between paying the child support or paying rent. And I can't in my right mind put my brand new baby and my stepdaughter homeless to pay my ex money for the kids when he's making more money than we are on a regular basis. I would absolutely love to be paying them. I would love to be able to help support them. That is my goal. And my boss is very understanding about the fact that I can't get to work. She said, as soon as I am able to get transportation, I'm able to start right back up. We've been keeping in contact every 15 to 14 days to make sure that I'm still trying to find a car. I've reached out to family members to see if they'd be able to help so that I can get back to work and get back to paying. Where there were payments to the child support, those were months when I had a steady job and had finally gotten all of the auto like taken out of my paycheck directly sort of payments, so that it was one less headache of trying to schedule payments and get everything figured out. I have applied at jobs for stay at home. There's not many that are actually hiring. Just kind of a, hey, apply, and then I never hear back from them. I just heard back from a job that I applied to in January saying that they were full and didn't need anybody. But I've been applying for jobs stay at home wise so that I can still be able to put money towards this. But if the $20 is going to make a difference, I will send the $20 we have, or the $5 or whatever we end up having left over. I will gladly send it. I just didn't think that was going to make that big of a deal, or even really look good to the court's eyes for me to be sending pocket change. So my apologies for not knowing that that would be such a big deal. And that's about all I can say right now with not being able to even get to work currently to help pay for this.
Briefly.
Yes, just so I just want to confirm. So, and I'm sorry to hear about the car accident. Nobody was injured. Everybody's okay, other than the car, I guess.
No lasting injuries.
Okay, I'm glad to hear that. Yes, Ms. Baldwin, go ahead.
So unfortunately, these are sort of similar story, different day. Anytime we come to court, it's always sort of a woe is me. Gee, all these things have happened. And perhaps that would make sense to consider if we were in a situation where I set the review like 2 weeks and we were sort of dogging her the whole time. This is a case where we are setting reviews out months at a time, giving her an opportunity to sort of get it together, and she never does. She makes these choices of, I basically want to be a stay-at-home parent to this new child that I chose to have and to my boyfriend's child. Instead of, the boyfriend has an obligation to take care of that child. That is not her obligation. So these are choices that are being made, and perhaps collectively between her and her boyfriend, but there's ones where they're consistently over a year, 10 months out of 12, deciding that the 2 children that she had with my client deserve $0. So again, we're making choices, and she's had a year at this point, or since April, I guess, since we filed the contempt, to get these things together. She just never does. And unless there are some true teeth to the court's order, she is never going to do so. So that's where, we've put it out long periods of stretches, hoping she would get things together. She just isn't. And unfortunately, we need to have a harsher penalty. And I believe that will unfortunately result in action, because so far what we've done has not resulted in really any action on her part. It's all, gee, I wish I could, but even now there's no stated plan on how she's going to pay. It's completely vague of, here's what I'm doing, here's what I've done. It's sort of all, well, if something comes around, I guess I'll pay, but that's about it. That's not appropriate when we're talking about child support. the children in my client's home even deserve support. This is a court order, not a gee, we'd like you to do this some period of time.
So I understand the frustration. I understand Ms. Stockwell's circumstances. We unfortunately, it's unfortunate the court often sees folks have kids and without the forethought about how they're going to support those kids. And in this case, it's I understand the frustration here. There was an order of child support entered in January that changed the support, the temporary support, and in the most recent debt calculation, it appears that as Ms. Baldwin stated, there was a payment made in July of $90 and August of $780 for a total of $870. And the arrearages just for this year alone are over $5,000. So while I understand making decisions between being homeless and providing for other children, there is an order in place. So here's what I will set a review for December 26th at 1 p.m. I would ask that Ms. Stockwell be present in person on the 26th at 1 p.m. However, Ms. Stockwell has until December 15th at noon, so that's next Friday at noon, to provide a plan to Ms. Baldwin's office regarding payment of child support. As you know now, Ms. Stockwell, some payment is better than nothing. No payment is kind of like a middle finger to those other two children that you have, and that's not appropriate at all. I appreciate you saying, well, we want to give bigger chunks. Doesn't matter. Frankly, the court would see a $25 a month, $50 a month payment as much better for everyone than 0.00000. If the plan that's provided to Ms. Baldwin's office is acceptable to Ms. Baldwin and her client, that date on the 26th can be struck. And if you want to renote it for another review, by all means, we can do that. If it is not acceptable by Ms. Baldwin, and so I'm putting the ball in Ms. Baldwin and her client's court for this. If that plan is not acceptable, then I expect Ms. Stockwell to be in person for court on December 26th, 2023 at 1 o'clock p.m. on the second floor of the Hall of Justice. And I guess the implication, Ms. Stockwell, is the court is most definitely considering jail time in lieu of child support, as this is just, it's gotten out of hand, and it's only going to get worse and worse the longer non-payment happens, and those arrearages are just going to keep growing, and then interest will start applying, and it's not good for anybody. Okay. So Ms. Baldwin has the authority to strike that 26th. And if they don't feel the plan is sufficient, and frankly, if there's some negotiation between the parties after you review the plan, I'm fine with that. I feel like Mr. Gilliam and Ms. Baldwin have been willing to work with you, Ms. Stockwell. So, you know, the sooner you get a plan to them, the more opportunity you have to have some discussions with them about how you're going to address this moving forward. Okay. Any questions or concerns?
No, Your Honor. Very good.
Thank you.
All right. Good luck.
I told Ms. Baldwin I would be on, Your Honor, when she had indicated to the court she had a matter on the adoption docket. She didn't realize that this docket was as short. She was hoping to be appearing in person after she finished the adoption matter. But I do have notes if Your Honor wants to proceed now, or if you want to give her a little bit of time and see if she's able to make it in the next 5 minutes. I'll defer to Your Honor.
I don't know that I have. I've got some folks in the waiting room that don't look like they are part of Kelly Ross and Lyra Stockwell. I think the only
I don't see anyone in the Zoom room.
Elena Gilliam.
I don't see anyone in the Zoom in the current room with that name, Your Honor. There's still a number of participants, possibly from the last matter, but I don't see the petitioner here. And the matter's on to review.
We've got a couple of folks. I'm going to bring them in and see if they're part of this
Perfect.
hearing.
Thank you, Judge.
I'm really not, I don't know what we're doing today because I didn't have a motion or anything.
It's a review. Back in December, there was review on a contempt originally found, I think, in June, where the court was setting reviews to confirm compliance with delinquency in payment of support. So it was on today for a review of that.
The last hearing I saw scheduled was back in December, I thought.
I believe it was December was the last review date, December 13, I think. Ms. Baldwin has the file, but she did review the material with me. In December, Ms. Gilliam was ordered for transfer payments from support. I believe it was $500 a month that included $17 of arrears in addition to the payment obligation. I'm just trying to find the note, Your Honor, in Odyssey. January 20th.
Now, what I've got at the last, looks like there was a hearing in December on the 5th that said a hearing on the 26th. And then that apparently didn't happen.
I think an agreed order was entered. They were able to work out an agreement, was my understanding. So I'm just looking here. And I apologize, Your Honor, trying to piece through. Okay, so December 12th, 2023, cover sheet to petitioner's arrears payment plan. At the court hearing in December, a review was set for if the parties weren't able to create an agreed payment plan. It reflected a payment plan of $500 a month with a review February 27th via Zoom here in court at 1 o'clock. And my notes are the payment for December was made in the amount of $500. January was paid in the amount of $500. And February, only $380 was paid. So again, delinquent. Our request was going to be to set a review in May. Our concern is Ms. Gilliam only makes payments when she is concerned about the potential for contempt. And even with a review this month, didn't make the full payment amount. So I don't know if she's one of these other names that have been let in.
You know, is Alina Gilliam present?
Yes, that is me, Your Honor. My last name is now Stockwell.
Oh, okay. Thank you. So we were just talking about your case. I don't know if you heard all that. I guess I'm trying to find whatever. I don't have an order.
So the clerk's minutes from the December 5th hearing, the court's ruling required petitioner provide a plan to Ms. Baldwin's office reflecting payments. It was set to review on December 26th. If plans agreed, then that date might not would be able to be struck. So then an email agreement was made that was filed with a cover sheet December 12th, reflecting the review date today, as well as a payment plan of $500 a month. And where we are today is December and January was paid timely, but February was not. February, $380 of the $500 payment has been made. There's $120 late for February.
In the agreement, we had, sorry, I didn't mean to interrupt, I'm sorry.
Right. Go ahead.
No, you're
In the agreement, we had said that 250 would be paid with the check that we would get on the 7th of the month, and then the other 250 with the second check we get on the 22nd of the month. Once that 22nd check did hit, I did make a payment. It doesn't pull until 2 to 3 days later, though, business days, it's set to pull today for the last 125.
It is in the email chain that she indicated that because of paydays that they would pull some on one pay, some on the next paycheck. It's possible because it's a short month that it did not reflect by the time of today's hearing in our prior contact with our client that it had been paid. Ms. Baldwin's request was going to be to set a review in May to confirm payments are continuing to be made. She did want the inquiry of the court to have a attorney's fee of 1 hour, $525, because it was delinquent prior to court today. We haven't been able to confirm with our client that it is posted, or if it posts tomorrow. Does not believe there had been attorney's fees previously awarded, and this has had to be reviewed many times because there is a pattern or track record of the payments not getting made timely. But I do see it does appear that what she reflected is in the email chain that was filed, that it would draw out of 2 different paychecks. So it's possible February's will be paid in full by the end of the month.
Right, and it looks like, I mean, it says basically 500 a month. Well, I'm at this juncture, I think I'm going to defer on the attorney fee. I'll consider that if we look at the record, when we come back at the next review and it didn't come in accordingly, then I'll consider that.
That's fair, Your Honor. I'll make a note for Ms. Baldwin that
Yeah.
reserve on attorney's fees, and we would defer to the court on a date in May. I can pull my calendar and make sure there are no significant issues. I think the only day in May where we have any issues would be the 21st. So,
Well, do you want, I guess my question is, do we want to review for the month of May, or do we want to review for the month of April?
I guess how about we review May 7th to make sure it's paid up to that point, which will get us through March and April, 2 more months.
I was either going to say that, or we could go into the next month to review too,
Or
but whichever.
How about we do June 4th? If we do May, it's really only going to be 2 months worth of payments. That gives 3 months to make sure that everything continues on the proper track. So if we did June 4th for review.
Are these being paid through support enforcement? Or to support enforcement? It looks like that's what this, so yeah, she's paying through support enforcement, correct?
I believe so, Your Honor, although I don't have the paperwork in front of me. I'm not going to talk so slow that Ms. Baldwin may show up there in front of you, but
I think it must be, because the payment history is from the SHS. So you're making your payment to the department, is that right, ma'am?
Yes, Your Honor, I am making it through the online payment services.
Okay. So what I'm going to propose we do, and only it's because of my experience in dealing with the SHS, would be to maybe propose we do this June 11th. And that's only to make sure we have a reflection of an accurate payment through the month of June, except through the month of May.
that's fine, Your Honor. And that's reasonable, just to make sure there's no delays through the processing.
Yeah, sometimes they have, depending upon when they receive something, it doesn't always reflect. So if we do it the 11th at 1 o'clock, 11th of June, and then we should be in good shape.
Perfect.
Yeah.
Thank you, Judge.
Your Ms. Baldwin just walked into the courtroom, so we're setting a review June 11th to reflect, to monitor the next 3 months, please. All right, so Ms. Stockwell, you understand you'll need to be present again, same way on the 11th of June, 1 o'clock. You need to make your payments timely for the next 3 months, and we'll see how that goes.
Yes, Your Honor. Thank you, Your Honor.
Okay,
Thank you, Judge.
you're welcome. I believe that is our docket. So. And a Gilliam matter that was on for review today.
That is on for review of child support. We did file an updated debt calculation, which shows that was filed back on May 30th, that sort of shows payments. And then we did receive from Ms. Now Stockwell a updated current payment. This is the third review. At this point, she does seem to be making the payments that are associated with the current payment and payment plan. So at this point, we're satisfied that she's going to continue making those payments, and that she understands that if she doesn't, that we'll bring her back on contempt. But at this point, we're okay to discontinue any further reviews so long as she continues to make the payments.
All right. And so, Ms. Stockwell, you understand that?
Yes, Your Honor.
Okay, so as long as you just keep making payments, then you won't need to come back to court. Okay? All right. So we will discontinue reviews until we hear otherwise.
Thank you.
Thank you.
Thank you.
Last